Item number 1, criminal petition 237/22.
We allowed a petition, 55 judges page, we can't read out here. Please take a certified copy and read.
Lord, if you
But
like,
we are allowing the petition,
Okay.
setting aside the
Hmm.
conviction.
if you like.
But the state government may, perhaps,
Yes.
if they want to verify, let them verify, but 1 month.
Within
One
month,
month. If you don't do it,
determining his national.
whatever, do whatever you want. We don't want to tell you what is to be done. 1 month, otherwise close. 6 years he has spent in jail.
Obliged.
Case.
Yes,
My
yes.
lord, yeah, yesterday I got the paper book, my lord.
Oh, yesterday only.
Yesterday only, my lord. So, my lord, I give me some time, my lord. Can it
This
be after a week,
number
my lord?
3 means
Item number 7.
item number 7.
7 and 8.
Jashimuddin.
Jasimuddin Bod Bhuya.
Oh, you got only today, yesterday.
Yesterday, my lord.
Then
Can it be after a week, my lord?
after a week. Yes, after a week, man. Mr. Learned Senior Counsel Amicus, appointed amicus in this dead reference, submits that he has received the copy of the paper book yesterday and a praise for a week time. This accordingly after a week.
My lord, first.
I'd like to mention for one motion matter filed on 23/11 woman.
It will come up. It will come up. You file, it will come.
It will take time. It will take time.
What do you take time?
Otherwise,
How long it takes time? How long it takes? If you file everything in, without any defect, it will come.
Yes, without any defect.
And then they will come. Why you are mentioning it? If you mention for every case filed, then see what will happen to this High Court. A writ petition also will say, I have filed, it will be listed. It will come. If somebody is creating problem, you tell us.
Woman, my lord.
Women on women in Article
Police run
14.
after her, my lord.
Article 14, men, women, everything. There is no we are equal.
Police run after her.
Doesn't matter. Police run after her.
Yeah.
And so far she is running faster than police. You keep running. She is running faster than police. So anyway, it will come up next.
May I please, your lordship? Matter was listed in the year 2019, lordship, on motion scale. On that day, matter was adjourned. Since then, matter has not been listed, lordship. May I pray for listed?
2019 it was adjourned.
Lord.
Then you left the profession or what? You are coming today. You got this 2019 matter adjourned in 2019 and today 2022 again, end of 23. I mean, we are going to celebrate New Year. Now you are coming. 19, 20, 21, 22, 3 years. Almost 4 years now. Did you leave your practice? No. Or you forgot about the case. Then your client reminded you, I have engaged you. What happened to my case? Am I getting a bail? Because the police is running after him or her?
Her.
In Assam, they are running very fast. See? And, okay, it will come up. Yes,
Please, your lordship, my lord, I beg to mention item number 24 to this list, my lord.
24. What do you want?
My senior is having some personal difficulty, my lord. Might be taken after a week.
Okay, on the prayer of Mr. Spencer. Yes. After a week. Yes, next.
May I please, your lordship? I beg to mention item number 11. My senior is out of station. Kindly matter may be adjourned for the day, lordship.
Okay, on the prayer of Ms.
G.
G.
Bora.
Bora.
Bless.
After a week. Yes, next.
Daily list for motion item 1.
LCR records have been received, so we'll look for hearing.
Yes, ma'am.
Unless it's a ex party or something, nothing like that.
You're contested.
Okay.
Obliged.
Item number 2.
Same. Ex party or something, I didn't know. You require proper hearing.
Yes.
Okay. Since the records have been received, the matter will be listed.
Item number 3.
Sonaman.
May I please, lordship?
Sonaman. What happened to you, Sonaman?
She is the citizen of India by birth, my lord,
Huh?
but the impugn order passed on the basis of three grounds, my lord, name discrepancy and Kabinama, that is registration of marriage, that was not.
So what is
accepted.
wrong with the order of the tribunal?
Page, my lord, 70 to 72, my lord.
Page 70?
70 to 72, my lord. And the Jamabandi not accepted due to not submitted the relevancy of other document, that is sale deed, revenue receipt, that was not submitted. That is what that is believe the Jamabandi. And on the three ground, my lord, that impugn order.
We'll issue notice, call for record, notice record interim.
Deep level.
Item number 4.
Records have been received.
His lordship, here my humble prayer will be to remand back the matter, because when this order was passed, impugn order was passed, at that time COVID period was there, and he could not prove all his relevant documents. Even the cross examination was not taken place. In this DW 123 was filed on the same day, lordship, on 1910, and thereafter 2-3 dates I have annexed the order sheets, lordship.
Page.
Order sheet is at page 49, it starts, lordship.
OP so and so opinion is passed in a type text reasons.
Yes.
File
File written argument on 26/5/2020, because he originally hails from Karimganj. So all documents he has to prove is from the district of Karimganj. Yeah, that at that time, and prior to that also, due to COVID-19 pandemic, the matter was adjourned.
There's some matter, is it in CAB, transfer cases? No.
Yeah.
CAB,
It's not TV lot.
Then?
It was supposed to upload.
when?
Lot, perhaps that was not picked up.
There was some transfer, do you have any idea? There's some
Yes,
transfer of
transfer by-
proceeding.
Yes, that is CAB as far as
CAB?
my, yes, as far as my
CAB,
knowledge,
I think.
It's not TV.
as far as.
think it's-
CAB, huh?
CAB lordship,
Okay,
if I am
CAB.
not wrong, it's CAB.
Janglu,
Yes.
CAB.
CAB. Here, he.
Okay, so, consume conduct opinion, hereby made absolute, what is interim bail? Presentation copy, what is that particular order you are agree with?
Agree, because if.
Which
he
one?
Order sheets, he paid for extension of cross-examination could not be conducted as learned SGB has resigned on so and so. Right, so 3 dates were there for cross-examination, and cross-examination was subsequently closed.
Couldn't be conducted, resigned.
Yes,
It is
lordship.
26/2, 3/1,
Yes, lordship.
resigned. On 3
Yes.
occasions, it was not conducted then on the
Then it was fixed for
27/3, 27/3,
argument.
then on, no, what is this? But then if the cross examination could not take place because the learned AGP has resigned, then what is to be done? Then
Then thereafter also he couldn't prove the documents because at that time COVID-19 pandemic was there. So to call for people from.
mainly when the adjourned due lockdown call by personal initiative for possible corona pen 23rd March. From 23rd March, copy is fixed for writing. It's 20. Then after that, what happened then?
Then
5.
22/6, 2020.
Consider
this-
conduct,
Yes.
safe kept, OPS file written argument,
Yes,
OPS
lordship.
been finished. Then,
Thereafter, the final order, impugn opinion.
in your opinion, what is the problem?
Problem is that I did not prove the documents in accordance with law. That means the issuing authority I have not called for, because PRC certificate was, then Jamabandi was exhibited. These were not proved.
If you are supposed to prove it, no?
Yes, lordship.
Then why didn't you prove it?
Because at the time pandemic was there, lordship, because COVID-19 pandemic was there, and the person has to travel from Karimganj to Tinsukia for proving the
Let him,
documents.
let him or her,
But
who is this?
Him.
it should be placed before the tribunal, Lordship. First.
Huh?
Yes.
Placed-
So my-
placed before the tribunal.
So
Lordship.
let the tribunal reconsider.
Yes,
But they have filed written argument, Lordship.
Why did you file written argument?
because at that time he couldn't prove the documents and not properly advised also that I have. So right now, if it's remanded back, he will prove all his documents.
What is that the observation of tribunal that he could not prove?
Yes,
Page,
Lordship. Page 19 is the,
page 9, huh?
yes, Lordship. Relevant portion is at page 23, Lordship. Mhm.
Which line? Which line?
Exhibit J,
The permanent residence certificate of info issued from Office Deputy Commissioner Karimganj. So far
Yes.
as this document concerned, it was not proved into law.
yes, Lordship.
Not testify witness to. When did you file this document?
This 2019. Because after,
Permanent residence certificate. Your.
yes, Lordship,
What is that? Show us that.
yes, Lordship. Page 85, Lordship. '86 is the original one. It's the copy and the typed copy is at page 85.
This certificate, who will prove?
Deputy Commissioner issued that
So who will come and testify, prove it?
on behalf of the Deputy Commissioner Karimganj.
Somebody can come.
So somebody, he will assign someone.
But you do not ask for any,
No, because at the time pandemic was there. If we see an entire order sheet, at that time COVID-19 was there. Lordship. So my humble prayer is if it's
no,
remanded.
because it is not just ordinary certificate. It is an ordinary certificate which confirms that he is a resident of Karimganj, Indian citizen. It's like a passport, 4 men's passport. It's like a passport. The certificate which says that he is an Indian. Yeah, permanent resident, obviously he must be an Indian.
Yes, Lordship.
Otherwise you can't, they will not
Yes,
give you a
even the
permit.
land documents are there.
So I think,
Jama
let us be examined then. Brother, Nikko. See,
I
because-
think tribunal has done nothing wrong, Lordship.
No, correct. But then see, correct. Was it that they have failed to prove? But then question is
They
that
have to take the burden is upon him.
correct. But then see, then he said that pandemic also.
Pandemic was there, Lordship.
In pandemic, everything was closed. No, we remember when there was a complete lockdown, you can't even come out. Only the dogs will roam around. Animals, it was a freedom for the animals. You remember in the TV we saw from the zoo, everybody came, they're having a nice time. Without being interfered by these human beings. Human beings are the greatest enemy of these animals. Either human beings will catch them, send them to zoo, or keep them as domestic animal, or kill them and eat their meat. The animals, human beings will never allow this freedom to the animals. So it was during COVID time, they had full freedom. They were roaming around in the street also. And Deputy Commissioner will be busy trying to enforce lockdown. He will not come to testify in favor of this Pfizer or something like that. He will be busy enforcing lockdown.
Even last year, 21, when I was practicing trial court, they were, if we send notice also, they were not coming because inter-district movements were restricted.
Interdistrict.
So they did not, steps were also taken, but they did not turn up. This is the practical problems being faced by the lawyers.
Okay,
in the-
Nico, in this petitioner had challenged the opinion dated 22/6/2022, 2020, passed by the learned foreigners tribunal Tinsukia in F. page 19, by which the petitioner was declared to be a foreigner of post.
1971 still.
Post. 20, why is that?
Page-
Post 25/3/1971.
Yes, Lordship.
Petitioner submits that the petitioner had duly appeared before tribunal on receiving the summons and also filed her written statement and also file a number of documents to prove that he is an Indian, not a foreigner, including the petitioner also in documents including not a foreigner, including the certificate, permanent residence certificate
Yes, Lordship.
issued by the Deputy Commissioner Karimganj, as well as identification certificate issued by the Secretary Lama Juar Gaon Panchayat, all certifying that he is a permanent resident of
Karimganj district.
Karimganj district. Petitioner also had submitted a number of other documents to show his linkage with his projected parents, father or parent,
Father, mother.
father, parents also, mother also,
Mother also is there in
mother,
66,
including voter list of 1966,
70,
70,
1970.
70, etc. Petitioner also submitted the original the sale deed. Certify or what? Kacha.
Jamabandi copy, Lordship.
Jamabandi copy
Yes,
of-
Lordship.
of land relating to a land in his name or father's name,
He inherited from his father.
which in his name, which he inherited from his father. Other documents have also been relied upon. Unfortunately, the COVID-19 pandemic broke out, resulting in difficulty on the part of the petitioner to effectively pursue his case. It has been submitted that the proceeding was pending before a foreigner's tribunal in Tinsukia, whereas he is a permanent resident of Karimganj, which added to his woes, WOWs, and WOES, woes. In as much as he had to frequently travel from Karimganj to Tinsukia to pursue his case before pending in the tribunal, in the proceeding pending before the tribunal, foreigners tribunal in Tinsukia. Under the circumstances, the petitioner could not take effective steps for proving the aforesaid certificates, more particularly the permanent residence certificate issued by the Deputy Commissioner as well as the
School certificate
school
also.
certificate,
Then Jamabandi. copy.
Jamabandi, identity certificate, etc., which would conclusively prove that the petitioner is indeed an Indian, not a foreigner. And to stop, it may also submitted that some of the documents were not subjected to cross-examination because of the absence of the learned
AGP.
AGP means Assistant Government
Public.
Leader, AGP, on account of his elevation as a member of the tribunal. First off, under the circumstances, it has been submitted that there are many reasons, as mentioned above, particularly during the COVID period, where there was strict imposition of lockdown, the petitioner could not take effective steps for proving the documents. It has been submitted that otherwise the petitioner has a very good case with credible and reliable documents to show that he is Indian, not a foreigner. Under the circumstances, it has been submitted that the petitioner may be given another opportunity to prove the aforesaid documents. We have heard the learned counsel for the parties and also perused the documents. We have also perused the original report which have been requisitioned from the learned FT. We have noted that the petitioner had indeed filed the aforesaid documents in support of his claim that he is an Indian, not a foreigner. We have also gone through the record which indicates that the proceeding, that during the pendency of the proceeding, the COVID pandemic had broke out and which resulted in serious disruption in the functioning of the tribunal. Because of the strict lockdown imposed, we also understand that it will be difficult for any person to travel from one district to another. Considering the above circumstances, we have the view, considering the above circumstances, and also considering the documents which have been placed on record before the learned tribunal, we have the view that the petitioner may be afforded another opportunity to appear before the tribunal to prove the aforesaid documents and the aforesaid documents and other documents relied upon by the petitioner. Accordingly, we allow this petition by setting aside the impugned order dated 22/6/2020 pass in so and so page 19. The petitioner will accordingly appear for the tribunal and take necessary steps for proving the aforesaid documents which have been proving the documents which have been relied upon by him in accordance with law. The petitioner will appear for the FT on when
Within 15 days.
he will appear within 15 days. The earlier interim order passed by this court. Any interim order passed?
Yes, Lordship, 29/9/2020.
Then will continue till the till the culmination of the proceeding before the tribunal. To let the LCR be remitted forthwith before the tribunal.
Lordship, one humble prayer, he may adduce more evidence also. His brothers.
Ms. Samita, he may be allowed, the petition may be allowed to file additional documents to prove that this is an aspect, the petitioner may file appropriate application before a tribunal and the tribunal consider the same in accordance with law.
Deeply obliged, Lordship.
Item number 5.
Abdul Khalil,
May I please?
yes.
This is contested case.
What is wrong with the order?
Wrong is the order that the petitioner came to be declared as foreigner only on the ground that the voter list of 1966 and 1970 does not contain any other name but only the name of his father. So therefore, the tribunal did not believe that I am the son of my father.
Will issue notice, Mr. Notice record interim.
Obliged.
Item number 6.
Munser Ali. Munser Ali.
In this case, Lordship, the petitioner and his elder brother has already been adduced evidence, But there, Lordship, kindly see page 11.
Yes,
Page husband, Lordship.
page 11, yes.
Page 11, serial number 4. No document has been filed by the OP as exhibit which links Mozir Ali, DW2, to their father Ahmad Sheikh and mother Gulbahar Sheikh. No document has been filed by the OP which proves that Mozir Ali is his brother. On these grounds, Lordship, I was declared foreigner, Lordship.
But he came and he was examined.
Lordship,
Your brother came.
Lordship, my brother.
Was he cross-examined?
Lordship.
Was he asked that you are not a brother, but you are a hired person?
No, Lordship.
No. Yes, Mr. Sharma.
Yes, notice may go, my lord.
Okay, notice record interim.
Obliged.
Item number 7.
Ramjan Ali,
My lord, this is an ex parte order, my lord.
why ex parte? Why didn't you go?
My
Why
lord,
you remain absent?
my lord, I was suffering from post-COVID weakness, my lord. The petitioner appeared before through his counsel on 8/7/2022.
Then?
After that, on 4 dates, his counsel appeared and took time. On the 5th date, my lord, he appeared, he was detained, declared as a foreigner. This is within 21 days period of time, my lord. He was detained on 29/7/2022. My lord, I may take you through this appropriate provision, relevant portion of the order, my lord. Page number 18, my lord.
Yes,
Page number 18.
yes,
It
yes.
says, on the other hand, the petition number 2398 of 2022 filed today, that is on 29/7/2022, bearing a statement at para number 2 thereof that on the previous date, that is on 21/7/2022, which was fixed for the appearance, the opposite party could not be able to appear before the tribunal as he has been suffering from the post-COVID fatigue and weakness, as he was take medication and advice for 7 days bed rest. The medical certificate copy is enclosed herewith as Annexure 1. My lord, within a period of 21 days, my lord, from the first date where his counsel appeared, my lord, he was declared as a
Yes,
foreigner.
Mr.
I may be
Will
released.
remand it, let him prove
Yes,
it. Yeah, Mr.
A.W. Aman.
Also, Mr. In this petition has challenged the ex parte order 29/7/2022 passed by page 17, by which he was declared to be a foreigner post
1971.
25 March 1971. It has been submitted to the petitioner, submitted that it is not a case that the petitioner was negligent and not willing to, was evading the process. In fact, after receiving the notice from the tribunal, he duly appeared before tribunal. Unfortunately, as he was suffering from post-COVID complications, he could not appear on the date so fixed. But his counsel was appearing. At a time, there was some difficulties also on obtaining the bailer, document of bailer, which complicated his problems. Otherwise, it is not a case that he was negligent. Unfortunately, the learned tribunal, taking into consideration that different grounds have been given for non-appearance, has proceeded to proceed the ex parte against him passing. We have heard learned counsel for the parties and also gone through the records. From the perusal of the opinion dated impugn opinion dated 29/7/22, it appears that the learned tribunal was persuaded to take this view to proceed ex parte on the ground that while the application filed by the petitioner on 29/7, 29/7, it was mentioned that the petitioner could not appear because of post-COVID complications. There was another application filed on 21/7/22 stating that there was some difficulty in getting the document for the bailer, full stop. And accordingly, the learned tribunal held that there were contradictions in the inconsistency in the explanations offered for his options. Also, next, we have the view that the aforesaid inconsistencies perhaps may not come in the way of the petitioner to prove that to contest the claim in MHS, if it is found that he was indeed suffering from post-COVID complications, and more so, this is an important proceeding where his citizenship will be decided. Accordingly, we are inclined to offer another opportunity to petition to appear for the learned tribunal to contest the claim, to contest the reference against him by filing a written statement and adducing evidence in support of his claim. When can you appear?
By the end of December.
Okay. Accordingly, the petitioner will appear before a tribunal within a period of 1 month from today, file his written statement and the documents in support of his claim and full stop. And the tribunal will accordingly proceed with the same in accordance with law. With the above observation, direction, the present petition stands allowed by setting aside the impugn order dated so passing so. It has been submitted by the learned counsel for the petitioner. The petitioner has been detained on the strength of the aforesaid impugn order dated 29/7/22. In that event, the petitioner will be allowed to go on bail, so as to effectively take part in the proceeding before the learned tribunal, for which the petitioner will furnish a bail bond of ₹5,000 with security like amount to the satisfaction of the SP border.
Jorhat.
SP border also will capture a biometrics iris, mobile number.
DP of left.
Item number 8.
Sorry, Fuddin. Sorry, Fuddin.
Impugn order page 30, my lord.
What is wrong with it?
Wrong here, my lord. My father's mother name appeared in the voter list of 1959. And my name also appeared with my mother, my lord, in 1989. But that is also not really. And my cousin, my lord, father's brother's son, my lord, he deposed in the court.
Mr.
That is
Sharma,
also rejected.
notice record interims.
SP, Golpa.
Item number 9.
Amirun Nessa.
Yes, sir.
She belongs to, it is against the order 69/2022 by the Kamrup Rural. The petitioner belongs to Assamese Goria Moria community. And father deposed.
Father came.
Yes,
Sharma,
Yes, Lordship.
notice record interim.
Masoblai.
Which district?
Kamrup.
Kamrup rural. Kamrup rural.
Now it is only Kamrup,
Only Kamrup.
only Kamrup,
SP, no, but then SP border Kamrup,
Kamrup.
or is it commissioner? I don't know. What is
No,
it?
no. Kamrup Lordship.
SP border Kamrup.
Only for Kamrup Metro. It's
Acha. Same, Iris and the
Kamrup.
phone number. Give a phone number. You have a phone number?
Yes,
Give the phone number. Yes.
Kamrup rural,
Yes.
not.
Item number 10.
Moinul Haq.
May I please your lordship, my lord. My lord, in this case, my lord, the tribunal, my lord, he issued, my lord, notice for the second time to the proceeding, my lord. And on the basis of, my lord, that notice, my lord, and on the date of appearance, my lord, for the first time, in the second proceeding, he was taken into custody, my lord, illegally.
In the first proceeding, what happened?
In the first proceeding, he was declared to be a foreigner post 2371.
You are already declared a foreigner.
That I understand.
You could
my
have
lord.
been detained on
Lordship-
the basis of the first opinion. So
Lord,
what
you
is
will
wrong
kindly
with
have a
that?
look at page 53, my lord.
Anyway,
In which
this-
manner he has been, my lord, taken into custody by the concerned tribunal, my lord. This is not his jurisdiction, this is not within his power, my lord. He cannot, my lord, take the proceeding into his
but
custody.
you are a foreigner.
That I understand, my lord, but
If you are a foreigner, then
but the
you foreigner,
learned
you are
member, my lord,
foreigner.
he cannot take him into custody on the day of appearance, my lord, in the second proceeding, my lord.
Why
The
not?
Second notice is barred by res judicata also, my lord.
Rejigata?
My lord,
How can we rejigata?
my lord, in the second proceeding, my lord, how can upon the proceeding, my lord, the
No,
second
no.
notice be
There is
served?
no bar lordship to make it.
You are a already declared a foreigner.
That, yes, my lord, that I admit, my lord.
Then,
But, my lord,
then you
on
are,
the- on the day of
therefore,
appearance, my lord, he was
therefore,
taken
that
into
is
custody.
merely a procedural defect. And you are, otherwise you are liable to be detained on the understanding of the earlier opinion.
My lord, the lordship will kindly have a look at page 53, my lord.
There is
this
no bar lordship. to
Order
make
has been
more than
passed, my
one
lord, by the
record.
concerned tribunal. Lordship will kindly.
Okay, notice record. We'll see again, recall for the record.
My lord, at
If
least
you have
some-
been declared a foreigner by the first, proceeding, then you are declared a foreigner. You have not challenged that. You have not challenged that.
that was challenged, my lord, earlier, my lord.
Where?
My lord, that
The
was,
earlier opinion declaring you to be a foreigner, was it challenged before this court?
yes, my lord.
Then what did the court say?
The earlier repetition, my lord, in the earlier repetition that was dismissed.
And therefore you go to
And my lord,
Bangladesh.
thereafter, my lord, the second notice was issued, my lord. And accordingly, on
Oh,
the day
they
of
are
appearance,
there because they thought that you are
he was
still
taken
here.
into
though
custody, my lord.
By mistake, they might have done it, but that mistake
My lord,
will not
lordship,
give
for a
any
moment,
benefit to you.
will kindly allow me, my lord, lordship, for a
That
moment.
mistake,
My lord.
that mistake, mister,
My lord,
will not give any benefit to you. Because you are already declared a foreigner.
that I admit, my lord, but this
If
learned
that-
tribunal, my lord,
because
he
that's
cannot
a
take him
fact.
in custody, my lord.
Let it record some
Notice,
lordship.
notice,
My lord, some
call for the
interim direction
record.
may kindly be given, my lord.
Interim probably consider on the next date on perusal of the records.
Yes.
My lord. Thank you.
Item number 12.
Yes, yes, next.
May please your lordship.
Item number
12.
Paplu. Paplu.
Lordships,
Paplu means
lordships.
what? Paplu means?
Paplu lordships.
Huh? We know Bablu, we know Papu. Paplu we don't know. This
Paplu
Paplu means
lordship
what?
is a small materials lordships. That is called Paplu.
Oh, small material. These are small pawn.
Indication of
Mm.
small materials lordships.
Now, what is the
Lordships.
problem? You have landed in trouble because you are small.
Lordships.
What is the
Lordship.
what is the opinion?
Lordship, page 13 lordships.
What is wrong with that?
Lordship, I came from Tripura lordships. My home is at Tripura lordships. We have 10 members lordships. Everything we have in Tripura lordships.
Then why did you
My
come to
brother is-
Assam?
Lordship, my sister was married to one Middle Kanti Pal lordships. He is having business at Guwahati Bamune Moidam. And lordship, I came to assist the business to him lordship.
Notice record interim.
Highly appreciated.
Item number 13.
Muhammad Ali.
Muhammad Ali, may it please your lordship. Impugned judgments and order is at page 48, your lordship. I have relied upon the voter list of 1966, 1970, having the name of the parents, your lordship, and some other credible documents, your lordship. And your lordship, Gavura was adduced to your lordship to establish the linkage. He has issued the certificate in favor of the opposite party.
This is Mr. Sharma.
Yes.
Notice record interim.
Deep obligation, much obligation.
Item number 14.
Johar Ali.
My lord. My lord, 64-year-old senior citizen,
Sorry?
64-year-old senior citizen, father name recorded in 1966-71.
Hmm.
The petitioner submitted Gabura Jamabandi. His elder brother appeared, my lord, before the tribunal and said that I am the elder brother. At this stage, my lord, interim may be considered.
But you have been arrested or what?
No, no, my lord.
No arrested.
I'm outside.
Okay.
Durham.
Notice record interim.
Item number 15.
Deputy of Fire.
Safura Khatun.
May I please, Lordship, in this case, my lord, brother deposed in her favor, my lord,
Brother, your own brother.
own brother, my lord.
How do you say he's your brother?
My lord, brother's evidence, my lord, kindly see, page 52, my lord.
Page 52. OP is my elder sister. Cross-examination. Oh, no cross-examination. Mr. Sharma, you should have asked a cross-examination that he is not your brother. He has been brought from the market.
And the evidence
Ah.
of the brother was not discussed in
See,
the
unless you question that,
impugn order.
okay, notice record in.
She has been detained, but
Okay, it has been submitted. How old are you?
63 years, my lord.
63. Mr. Sharma will have problem keeping old people in the detention. Don't take the risk. If anything happens, you will be blamed. Let him. Okay, likho. It has been submitted at the bar that the petitioner has been detained on the strength of the impugn order dated so. Having considered the materials record, we are of the view that she may be allowed to remain on bail during the pendency of this proceeding. Accordingly, the petitioner will be allowed, the petitioner may be released on bail on furnishing a bail bond or piece so and so. Everything is same. You have got mobile phone.
Yes, ma'am.
She knows how to use mobile phone.
My lord, her son has mobile phone, my lord.
No, okay. Her son has mobile phone. But if the son goes for work, then what will happen?
My lord, she is illiterate. I don't know, my lord, whether she can use mobile or not. My lord.
You buy a mobile phone,
Yes,
everybody
yes,
can
yes.
use
That
mobile phone
can.
now. Buy a mobile phone, give a SIM card,
Yes, my lord.
then
can.
you in her name, and because it will be easy for the government to, police to monitor whether you are there. Because your son will go
Lordship.
for working, he will go somewhere, Qatar or somewhere, he will not come back, then what will happen?
Lordship.
Mobile phone will also provide mobile number.
Obliged.
Item number 16.
Yes, what
May
is
I
this?
please, Lordship, my lord, this is a
Item number
contested
16.
case, my lord. And the petitioner father name recorded in 1966, 77 onwards, my lord, on the ground that all the voter lists, my lord, computer generated, that was not examined by the election officer.
Yes, Mr.
And
Sharma.
brothers and
Notice record interim.
Hello, obliged.
For admission, item 17.
What is this?
Lordship, LCR receipt, matter may be fixed for hearing.
Okay. Yes, next. Fazila Khatun. Yes, madam.
Item number 18.
Lordship, matter will be fixed for hearing.
Don't want to hear today. No hearing today.
No.
You know anything about the case?
No, Lordship.
No, that is why you said. Is it ex parte matter?
No, my lord.
No. Huh? Ex parte? Contested? Okay.
Obliged.
Same.
Item number 19.
Vindhya Namsudra.
Please, your lord. My lord, I think the LCR has been received, my lord.
Why he was declared Vindhya? She? Huh?
See.
Why she was declared foreigner?
Declare it's not tenable according to me, my lord. Page 26 is the
Why not tenable?
because her two sisters were the two reference case was here, but in those two cases
They were declared Indian.
Indian, but she has been
Yes.
declared foreigner. And whereas the father has also obtained the Indian citizenship.
Maybe you are born in Bangladesh.
No. I was born in here only, that too in the year
And
1980.
your two sisters born in India. Huh? No. Yes, Sharma, two sister Indian, she is foreigner. One third is in foreigner. How can it be? Huh? What is the document you have annexed?
He has to establish her link with her projected father.
But did your sister come and depose that she is my sister?
There are only three. Yes, my lord. I think
They came. What do I
Yeah,
think?
they came.
Vadumbai.
DW2 and DW3.
Let us see, DW2, DW3. DW1, 2, 3. Who is DW1, DW2?
DW1 is the petitioner herself,
And DW2?
DW2 is Janu Rani Majumdar.
Let us see.
No, I think so. My lord, I have to go through the LCR, my lord.
Very
because
good, thank you.
documents
Please
is not
prepare and
included.
come. Otherwise, if you prepare in the courtroom, then whole day will be,
I have to go through the LCR.
please go through everything. Okay,
and some other.
list the matter, hearing.
Item number 20,
Obliged, ma'am.
Yes,
May I please your lordship? LCR has received through matter may be fixed for hearing lordship.
same.
The
item number 21,
Muhammad Ali.
My lord, it is a clear case of notice was not served to me, lordship. Order
Not, you
not
not
served.
served.
order is reflected, lordship. Order is
It
based,
was served to whom?
my lordship, I was lordship in Grand lordship, in the year of 2004 lordship, in Jorhat lordship.
Jorhat, then
Yes. Order, can you see the order? Order is
Lukli Ram, sorry, Muhammad Ali. Let us-
Mahmoud Ali,
Mahmoud Ali.
27.
You are
lordship.
a suspected Bangladeshi.
My lord, 27. Today witness on behalf of state is present, OP absent without step. As reported in the notice by serving person, OP left the place of abode for unknown destination.
So
Next page is the lordship
I have the honor to return the notice unserved. That is.
answer.
This is.
And notice is page lordship 29 lordship.
Mr. Sharma, I think there is not a proper, Mr. What is your name? A Hussain, and Mr. A Hussain, Lana Council for the, also Mr. for the, in this petitioner has challenged the ex parte order dated. Page number? Page number?
27.
Ex parte order dated 18/8/2010, by which the Learned Foreigners Tribunal Jorhat declared the petitioner to be a foreigner of post 25/3/1971 in JFT case number 2047, page 27. It has been submitted by Learned Council for the petitioner that the proceeding was, that the Learned Tribunal proceeded ex parte against him without proper service of notice upon him. In this regard, it has been submitted that the petitioner was earlier staying in Jorhat.
Yes, ma'am.
Jorhat, while he had gone, he was working temporarily to earn his livelihood, and he left Jorhat and now staying in where? Nagaon. Unfortunately, the notice.
My lord, judgment was delivered on 2010 lordship.
Okay, no problem.
But
We have called for the records now, 2020. We have, once we have record, having called now final, we can dismiss now at this stage. And also ex parte also, no?
Yes.
He not served. Kya? Last sentence.
Sorry.
He बोलते.
The petitioner was also staying in Jorhat while he was.
And now staying in Nagaon. It has been submitted that unfortunately, the notice was sought to be served where he was earlier staying in Nagaon. Nagaon, huh? No, no.
Yes, ma'am. No.
No, earlier.
Nagaon.
Earlier. Jorhat.
Earlier.
Jorhat. Notice was addressed in Jorhat or what?
Jorhat, sir.
Okay. I know that. And yes, Jorhat. In fact, the state can be ascertained from the records. Under circumstances, it has been submitted that since the petitioner was not properly served notice, the impugn proceeding will be liable to be set aside so as to enable the set aside and the petitioner may be allowed to take part in the proceeding to contest the reference against him. We have gone through the original records requisition. In the original record also, what we have noted is that notice was addressed in his name in the earlier address at No Kachari. No Kachari, Tiniali, care of Sri Dilip Borthakur, Moriani Thana. Full stop. In the said notice, it is also mentioned by the said Borthakur that the petitioner was earlier was working under him, but he has left about 3-4 years ago. Thereafter, we also see the endorsement. The remark made by the process server stating that the notice has been written unserved as the person concerned was not found at a given address. So next, we have the view that if the person had left the address and could not be served notice, the tribunal ought to have ascertained to the concerned SP, concerned SP, and push from next para. If the notice could not have been served, because of the change of address, there is other provision for the other method for service of notice, but which does not appear to have been adopted in the present case. First of be as it may, since the proceeding was conducted ex parte against him, and as the petitioner is willing to challenge the reference against him, we afford another opportunity to the petitioner to appear before the FT Tribunal, Jorhat, file a written statement and all the documents in his support that he is an Indian, not a foreigner. So accordingly, for the reasons described, we allow this petition by setting aside the interim ex parte order dated so and so and so. Petition will appear for the SP tribunal. When will you appear?
January, Lordship.
What January?
13 January.
1 month. With a period 1 month from today. And file his written statement and also document in support when the Lana tribunal will proceed with the matter in accordance with law. He also provided that you have been on interim. You have got some bail.
Yes, yes.
The earlier earlier order dated 22. Earlier interim protection granted to him by order dated 22/2/22 by this court will continue till culmination of the proceeding before the tribunal. Let the LCR be remitted forthwith to the concerned FT. Next.
Item 22, Lordship. This is the case of Lordship res judicata, Lordship.
Res judicata?
Yes,
Khairun Nisa.
Khairun Nisa. Order, Lordship, expertly order is page 21.
But this is a fresh case of what? LCR is there or what? LCR is there. Khairun Nisa.
Clear case, Lordship. Earlier order, Lordship.
Earlier order is page
14, Lordship.
Page 14.
Yes, ma'am.
Reference will be against Musammad Khairun Nisa, wife of Abed Ali.
Abed Ali, yes, ma'am.
And resident of? What is the resident? Let us see. Khairun
Zera Thani, my lord. Zera Thani.
Resident of Jomari. No. Where? Last page 15.
Brown Village is Zera Thani, Lordship. Jomari, he
I
married.
find that Khairun Nisa was born in village Jarathani but was married to one Shanshu while she was suspected illegal woman. I have resident is not a foreigner. Now in the present
Present case is my lord page 21, Lordship.
page 21. Page 21.
Yes, ma'am.
Page 21.
Notice was served, Lordship, to me.
Khairun Nisa, wife of Wahed Ali.
Wahed Ali, Lordship.
Oh, Ali was Abed Ali. You
No,
have
my-
married another person.
No, my lord. Kindly see the first paragraph, Abed Ali written. Lordship, typographical mistake, Lordship. Mistake by the code, Lordship. Kindly see the next paragraph. Earlier order, Lordship. Earlier order.
Ali order, page
Page 15, kindly see page 15.
Page 15, where is it? Wahed Ali was born. Wahed Ali. Oh, the same husband, huh?
Same as well.
Oh.
Same as in
Village Dokhin Jaumari.
Zeomari. He married to Dr. Zeomari.
Geomari. Rupohi. Then, okay, then in this order, ex parte order, ex parte order.
Expect order, my lord. Notice was not sub, properly not served, lordship. Kindly see the notice.
What you are not served properly?
Properly, my lord.
Hmm.
Page 18, my lord.
Page 18.
Hmm. In pursuance to the order of the court, we have reached at the house of Musammad Khairun Nisa, wife of late Wahid Ali. Lordship, my husband is alive.
What they said is someone উল্লেখ আছে মিস্টার ওহেদ আলী গতিকে সমনখন তেওঁলোকে গ্ৰহণ কৰিবৰ বাবে অস্বীকাৰ যেটা লেট উত্তৰ খাইৰুন নেতা আমি ওহেদ আলীৰ নামত বিদেশী গোচৰ ধৰা হয় আদালতে তেওঁলোকক ভাৰতীয় নাগৰিক বুলি ৰায় প্ৰদান কৰা প্ৰমাণপত্ৰ আমাৰ হাতত দাখিল দিয়ে গতিকে সমনৰ লগতে ৰায়দানত কপি এটা গাঁঠি পুনৰ মহোদয়ৰ প্ৰেৰণ
Lordship, how can I receive it, Lordship? My husband is alive.
when they went to serve notice, because it was late 20. I'm still applied notice. That is the judgment. So they have returned the judgment from it.
You go to tribunal, tell that this is wrong, so that you are so and so. You go there, go to the tribunal, and you show that I am so and so wife of Wahid Ali.
In notice, Lordship, late Wahid Ali. But
Huh?
my husband is alive. How can I receive it, Lordship?
Oh, yes, correct.
How can I
you
receive
say, when you say that, when you describe the living husband to be the dead husband, why should she
How can I
accept
receive?
also? Sharma,
Ah,
you make her husband dead. Obviously, she is
Ah.
angry.
how can I receive it, Lordship?
Mister, you have to be careful, Mister. When you serve notice, he said, "Oh, take this. Your husband is dead." She will. You are lucky that she did not beat you up. Huh?
That is the view of this court. Court said that the Xerox copy is given. Therefore, procedure.
Order copy I have given, Lordship.
Has not come forward before it is going to state the aforesaid fact and thereby prove the copy, the present proceeding that Musammad Khairun Nisa so is the same and one person. Unless I find no alternative except to pass an ex parte order.
Even Lordship, processor server Lordship told me at present you not.
Okay, you go there. You show this certificate. He says, "I am this wife of Hawali. Please close it." You say that it will be better because. Okay. And Mister.
A Hussain.
Hussain Lane counsel for the petition, Rahul Lane counsel for the. In this petition, the petitioner has challenged the ex parte order dated 7/12/2019 passed the land FT 3rd Nogam in FT case number so and so page 21. By which the petitioner was declared to be a foreigner of post 25/7/1971. It is a specific plea of the petitioner that first of all, the petitioner was not served with the notice properly, and secondly, the petitioner also had been declared to be not Indian by a foreigner's tribunal in an earlier proceeding by foreigner's tribunal Nagaon in FT earlier proceeding by the foreigners tribunal Nagaon in FT case number 635/07 within bracket D by order dated 29/2021, and as such the present
My lord, order dated 2011. 29
29/2011, and as such the proceeding is liable to be set aside. We have heard learned counsel for the party on perusing matters record. The original record indicates that when the notice was sought to be served to the petitioner's husband has been wrongly shown as late Wahid Ali, because of which the petitioner refused to accept on the ground that there is a wrong description. Further, it has been from the record, it is also seen that the proceeding herself gave a copy, furnished a copy of the earlier opinion rendered by the foreign tribunal in declaring her to be Indian and returned the notice. However, first of the learned tribunal, though acknowledged the aforesaid facts, still decided to proceed ex parte on the ground that she had not appeared before the tribunal. full stop. Considering as far as service of notice is concerned, this court certainly cannot put the blame on the proceeding in as much as the description of the proceeding should have been properly given. Since the petitioner claims that her husband is still alive
Yes, ma'am.
and not dead, the description of her husband as a late Wahid Ali does not appear to be proper. Be it as it may, the fact remains that since it is a specific plea of the petitioner that she was earlier declared to be Indian, not a foreigner. If that is so, the subsequent proceeding will be not maintainable by as the principal res judicata will not be applicable in view of the application of principal res judicata in the light of the decision of Honorable Supreme Court in Abdul Quddus versus India in 2019 volume. What?
2019 6 SCC 604.
19?
6 SCC
6
604.
604. Also, we are also of the opinion that if the petitioner had indeed been declared Indian by the earlier opinion dated 29/2011 in FT case number 635 by the Learned Foreigners Tribunal, Nagaon, the present subsequent proceeding will not lie. However, since the matter, according to the view that the petitioner will appear before the Foreigners Tribunal and file the necessary certified copy of the earlier opinion and prove that the present petitioner is the same person who was declared to be a Indian. And the Learned Tribunal, after considering same, will pass appropriate order as to whether the present petitioner and the present proceeding is barred by res judicata or not. If it is found that the present petitioner is same person who was declared to be Indian in terms of the earlier opinion dated so, the proceeding will immediately be concluded in favor of the petitioner declaring to be Indian. On the other hand, if the tribunal takes a different view, that the tribunal will record the reasons for the same which the petitioner so that the petitioner can challenge before the appropriate forum. The Learned Tribunal can proceed only if it is found that if it is a view that the petitioner is not the same person who was proceeded earlier. The petitioner accordingly will be entitled to challenge such opinion of the tribunal, including the opinion as regards the applicability of res judicata. Okay, petitioner accordingly set aside by petitioner allowed by setting aside the ex parte order dated so. And the petitioner will appear for the FT Foreigners Tribunal. Foreigners Tribunal. Nagaon. When can you appear?
Next one.
1 month. Within a month.
1 month.
Within the period 1 month from today.
Okay.
The Learned Tribunal, after hearing the petitioner, will pass appropriate order as observed earlier, as above. Let the original record be LCR be remitted forthwith to the concerned FT.
But I mean bail receipt.
Since the petitioner have been granted a bail.
Why order dated 14/2/2000?
No. It was not granted bail.
No. Stay order was passed.
It is also directed that since during the penance of this the proceeding before the tribunal, the petitioner shall not be arrested, detained. However, she will appear before the SP border. Nagaon. SP border Nagaon. Furnish bail funds. Bail bond 5,000 scheduled like a month. Phone number. You have a mobile phone.
Yes, I have a mobile.
Let her purchase a mobile phone. Give a mobile number to the SP border.
Item number 23.
Rup Bhanu. Since the records have been received, the matter. What is this?
In this case, Lordship, brother's evidence was not considered.
Consider. Why?
Yeah. Because
Not at all considered, not discussed.
discussed,
Then
not considered because there is no documentary, but voters list of 1966 of father and mother 70 of mother and 2 elder brothers. Subsequent 89 voter list of mother and the other brother, and the brother who has adduced evidence as DW2. He has casted vote along with his mother in the year 1989. And Gaonbura also has adduced evidence as DW3 lordship.
Their opinion had not been considered.
Yes, brother, why not considered? I'll just read out that portion.
Para,
Page
Yes.
42.
page 42, yes.
Page 42, second paragraph, lordship. The statement of DW2, that is Abdul Ali, who claimed to be the brother of the OP, cannot be relied upon as the oral testimony of DW2 alone, since any documentary support cannot be treated as sufficient to prove linkage.
And
Or
is there
help-
any documentary evidence?
Yes.
What is it shows the thing?
1989 voters list.
Page,
lordship.
page,
Page 69,
page 69,
yes, 70, if we see.
page 69. Page 69,
And 70 relevant portion, Abdul Ali is my brother.
Abdul Ali, son of Munsir Ali.
Yes.
And here your name appears also.
No, no, my mother name is there,
What is that, mother?
Belatan Nessa
Betaneta.
Munser Ali.
So this is a documentary evidence there, whether you believe that's the difference.
Already
And
this
six-
is- let it come up for hearing.
No, what we'll remand it later, let the tribunal again reconsider.
Yes, lordship.
See, because see, there is a documentary evidence is there.
Yes, lord.
How it is to be, how much is see relevant or that they can be decided by the tribunal. We don't want to make any opinion. See, you are the petitioner claims that she is the daughter of Munsir Ali.
Yes,
Huh?
lordship. Yes,
What is that
lordship.
claim? Please. Munsir Ali,
Yes, lordship.
Munsir Ali, what is it? How is it?
Evidence also, lordship.
No, electoral roll. She, Munsir.
Munser Ali, yes, lordship. Electoral roll of 1966, lordship, page. Page
Munser Ali.
65, lordship.
Of the same village,
Yes, lordship.
same village.
Yes, lordship. Then 70 voter list of my mother and 2 brothers.
Different places.
We are remanding.
Yes, lordship.
And Ms. Ghosh Danika also. In this petition, the petitioner had challenged the opinion dated
27/1/2022.
passed by the so page 37.
But what is the link, my lord?
Oh, that, no problem. The tribunal, she will argue, but it is a fact that the documentary evidence is there. Let the tribunal say that this documentary evidence cannot be relied upon, whatever reason. Let the tribunal give, because that this voter list of 1965 showing her father's name and her brother's name relates to the same village. If it is a different village, then one can say, oh, that Munsir Ali of Nagaon, we don't know. Not reliable. The same village.
Yes, lord.
Munsir Ali of the Bedbari, Bantipur,
Banti-
Borpeta, same village.
Same village,
हाँ.
lordship.
So, क्या लिखा?
70 also mother is there.
In this petition, the petitioner has challenged the opinion that is 122 passed by the
Land information page 37. Though a number of grounds have been taken, Ms. Ghosh has drawn our attention to one of the reasons for rejecting the claim of the petitioner. The learned tribunal observed that the statement of DW2, that is Abdul Ali, who claimed to be the brother of OP, cannot be relied upon as the oral testimony of DW2 alone, since any documentary support, cannot be treated as a sufficient proof to linkage or help the cause of the OP. Page 42, para 2. It has been submitted by Ms. Ghosh that it is not correct that she did not produce, the OP did not produce any documentary evidence. In fact, that she had filed the electoral roll of 1989, in which relating to Bantipur village of Betawari Mauza, Borpeta subdivision, relating to Suru Saru Khetri, 46 Legislative Assembly constituency, where the name of her brother Abdul Ali is shown as the son of Munser Ali. In the same voter list, the name of Belaton Nessa, who the petitioner has projected to be her mother, is also shown along with the said Abdul Ali. It has been submitted that the petitioner has been projecting the Munser Ali as her father, whose name appears in the voter list of 1965 in respect to the same village. Under the circumstances, it will be it is prima facie wrong. It has been submitted that it will be completely wrong on the part of the tribunal to hold that the petitioner had not adduced any evidence, had filed any documentary evidence. Under the circumstances, it has been submitted by Ms. Ghosh that that since one of the grounds, since one of the reasons assigned by the learned tribunal is found to be prima facie not sustainable in law, the entire opinion will get vitiated. We have heard having heard the learned counsel for the parties and also on perusal of the material record, we have also noted that the petitioner had indeed claimed Munser Ali to be her father, whose name appears in the voter list of 1965, as well as in 1965.
Right.
We also in respect of Bantipur village under Bedbari Mauza of Borpeta Sadar subdivision in respect of Saru Khetri 53 Legislative Assembly. We also have noted that the voter list in which the name of her projected brother Abdul Ali is shown, it also appears in respect of the same village under the same Mauza of the same subdivision, Borpeta Sadar subdivision in respect of Saru Khetri 46. And in the said voter list of 1989, where her brother's name is shown, it is Abdul Ali is shown. He has been shown to be son of Munser Ali. The same voter list also shows the name of one Belaton Nessa, who the mother of the said, who is shown to be the wife of Munser Ali. Under the circumstances, we have the opinion that it cannot be said that no document had been filed by the petitioner as held by the learned tribunal. On the ground, we hold that the opinion rendered by the petitioner by not considering a relevant and material fact document would be rendered vitiated. In as much as if any opinion is rendered without considering the relevant and material evidence on record, such an opinion cannot be sustained in law. Accordingly, for the reason discussed above, without going into the merit of the case in respect of the grounds raised, we allow this petition by setting aside the impugn order so and so, passed by learned so and so, and the matter is remanded for fresh reconsideration, and the petitioner will be permitted to raise all the grounds afresh, and the learned tribunal will pass a fresh opinion, even though this court has not considered the validity of other grounds raised in this petition. With the above observation and direction, the present petition stands allowed. I have said set aside. No, accordingly set aside. Petitioner will appear before the FT board, FT on within a period of will appear within a period of
15 days.
15 days. 15 days. Okay.
Yes, sir.
But my lord, everything has been discussed, my lord, in this.
No, others we are not discussing because that itself is a it can vitiate. We are not.
Because 65, my mother also has casted.
Therefore, in the paper within a period of 15 days from today, and the learned tribunal will hear again the petitioner, and upon hearing will pass a fresh order.
My lord, she may adduce evidence because one document was not proved.
Petitioner submits that petitioner may be allowed to adduce additional document and evidence. This is an aspect which the petitioner can always approach the tribunal, and the learned tribunal will consider same in accordance with law. So stop next para. Let the LCR be remitted forthwith the petitioner will be allowed to remain on bail in terms of the
23/5/2022.
from the earlier order passed by this court in 25/2022 till the culmination of the proceeding before the learned tribunal.
Deeply obliged.
For orders, item 25.
Ashad Ali, what happened?
Arshad Ali may be taken up
Okay.
tomorrow, Lordship,
Why tomorrow?
because today I'm not well prepared with this case.
22. Yes, since the records have been received, the matter will be listed for here.
Deeply obliged. Lordship.
Supplementary list for orders, item 26.
Aye, Akram Ali, what is the problem?
Lordship, he could not appear
Why?
before. Lordship,
Why he could not appear?
because of gap of communication gap, Lordship.
What gap of what communication gap?
Lordship,
How do you communicate?
Paragraph 6. Lordship.
How do you communicate? By telegram, by physical mode, belgari, mobile phone? How do you communicate?
He has given one of the number of co-villagers.
Co-villager.
Yes. There was nothing like this.
And he doesn't have a mobile phone.
No, Lord.
You ask him to purchase mobile phone immediately and come tomorrow. See, that is why we insist that the proceeding must have a mobile phone of his own. Therefore, this kind of problem will keep on occurring. You will say, my co-villager. Nowadays, everybody has got a mobile phone.
Lordship,
Anyway, what do you want? Tell us.
Lordship, the date for appearance before the border should be extended.
Okay, then you, in the meantime, purchase a mobile phone and give a number to the SP border also.
Lordship, perhaps his position is financially not so.
No, you have to purchase. Otherwise, we will not grant you. How do the authority monitor your presence? If you give the mobile number of your friend and your friend goes to some other country, Saudi Arabia, Qatar, Canada, UK, America for work, then what will happen?
The mobile phone is lesser than his.
Mobile phone?
Mobile phone, Lord. Is lesser than his.
You have heard?
Let's.
You repeat that, Mr. Sharma. Mobile phone. We allow only on that condition. Buy a mobile phone. Ask Mr. Akram Ali.
Akram.
Ask him to buy a mobile phone. Okay, likho. And Mr. Lane counsel for the applicant, also Lane counsel for the present application has been filed seeking extension of time for appearance before the SP border.
SP border.
Hojai. It has been submitted that though this court passed the order on 8/8/2022, granting bail to the petitioner and directing him to appear before the SP border Hojai. The applicant could not appear before the SP border Hojai in time due to communication gap. We have the view that when any such direction issued, the applicant must be always within easy access, should be easily communicable by the authorities concerned. Under the circumstances, while we allow this application, allowing the applicant to appear before the SP border Hojai within a period of how long you want?
15 days.
15 days from today. The applicant shall also furnish a mobile contact number belonging to him to the SP border Hojai, so that the SP border Hojai can communicate with him directly as and when required. With the above observation and direction, the present applicants can disposed of. Is allowed and disposed of.
All the cases are lodged, but rest 2 cases. There is.
Next 2 cases also this
Also
same.
communication gap,
Yes.
mobile phone.
Item 27.
We will not tell you which connection, Airtel, Jio, that
That's
is
it.
up to you.
Yes.
BSNL, but is up to you. Then we'll be favoring some company that we don't want. You buy any mobile phone. Yes, same order, item number 27, 28,
28.
same. SP border Hojai.
Hojai, but the date of case number is different.
27, date is?
His date is 10/8/2022.
And the item number 28?
This is earlier, all lordship.
Case number is 6-10-21, Lordship.
Okay. Black.
Daily list of orders. Hearing list, additional hearing list. Anyone for the hearing list?
Criminal.
Criminal.
We shift our jurisdiction from foreign to crime. Huh?
No councils, it seems.
There is no,
No Bijita also.
no Bijita, no criminal lawyer beside,
Mhm.
all foreigners lawyer.
Lordship as a single bench, perhaps they are waiting.
Oh, single bench also there.
Yes, yes.
Huh? Single bench.
Councils are waiting.
You are for
Item number 7, ma'am.
of criminal
Yes, ma'am.
appeal.
Reference matter, my lord.
Oh, that reference. Item number 7 today, I think one senior advocate, no? Mr. T.J. Mohanto, he said that he had received the paper book only yesterday. So we had granted one week's time. So please come after 1 week, Tariq decision again. 8/12, please come on 8/12. We'll take it up. We'll take it up. Any other criminal matter appeal? Yes.
Can we have it on 7, ma'am?
You have a word with Mr. T.J. Mohanto. Whatever is agreeable, we'll take it up. Okay, so please have a word with Mr. T.J. Mohanto. Yes, Jahan.
Councils.
Everybody is scared to appear against you or what? Everybody is running away.
Cannot be. I
Huh?
don't know. That should not be.
Devi, any criminal matter? You know, sometimes we feel like as if we are in the market. You come and buy this product. You sit in the market, no?
Yes.
And you know, so you have to wait for the customer to come to sell your commodity. So we have the cause list with us.
Part
Ah.
matters, it generally happens.
Huh?
In part matters, it normally happens.
So we are requesting the lawyers to come and argue before us. We are waiting. No lawyer is ready.
They are all waiting for single benches matter.
Single bench matter.
Mr. Kaushik Goswami has one, but today he is out of station, no?
Item number 32 is otherwise paper today is not there, my lord.
That item number 1,
Number 32, my lord.
item number 32.
Bijuli Wala.
Oh.
BJP.
Unfortunately, in this criminal appeals, we can't proceed without hearing the. Otherwise, we would have cleared the fire, this cause list, but then nobody is there. Hearing. J. Saikia names. J. Saikia, PJ Saikia.
J. Saikia, Miss Bijita Sharma had spoken to him.
Oh, is there?
And she had spoken to him. She has won analogous matters with J. Saikia, but then again, he did not come. Otherwise,
B. Prasad also there, Krill J. Amicus.
oh, Pri Prasad, I can inform him, but today I have not seen him.
PJ Saikia. Then A. Chaudhary. See, is a live streaming, no? If these prisoners are able to have access to this, they will say, oh, what has happened to our lawyers? We are spending jail. We are pissing chakki, and the lawyer is not appearing in the court.
A notice can be displayed in the, can be shown in the display.
It shall be the notice.
Cosely is also.
Yes, cause list will be noticed.
B. Devi is there. Who is this B. Devi? Miss B. Devi.
B. Devi, I'm not able to.
Rahman Borgohai, Gorlosa, Abdullah Borgohai, H.R. Chaudhary. Oh. Wait.
H.I. Chaudhary's duty, Mr. H.I.
So B. Prasad also not there, huh? There are so many B. Prasad. Mahajan, P.K. Das, N.J. Das, A. Chaudhary, Mahajan, Ali, S. Islam.
Mahajan's sons got married yesterday.
Whose son?
Mahajan's son got married yesterday.
Then Islam, Saikia, Hazarika, Mukul Deka. A.J. Sharma, N.S. Laskar, M. Hussain. But today is a hearing day, no? Today?
No.
No, today not a hearing day. Oh. Y. Chaudhary, A.Y. Chaudhary, Rajbor Bhuiyan, M. Burman. M. Burman, who is this M. Burman?
Meghali Burman.
Is she there? No.
She was a little
Amicus.
while ago doing a matter in court 6,
Ah.
Amicus matter only. Perhaps she's still there.
Just see, M. Burman,
Court
Amicus.
6.
Then there is also Rupjit De, Amicus. Rupjit De.
I can inform it.
M.S. Laskar also there. Lot of Amicus. Amicus are missing. B. Sharma. Vijita also there. Item number Indreswar Bora we did yesterday. Yesterday, yes.
Tomorrow the matter is fixed.
Okay. Porbina Begum, Intekha.
We have already purchased the
Oh, Indresa Bharati.
killing wife.
Sanjeev Mondol, S. Kolita, Ganesh Tanti, T.J. Majumdar, Raju Kumar Deka, Miss A. Goswami. Who is this Miss A. Goswami? S.C. Kayal, Barua, Talukdar, Chaudhary, Mr. S.D. Purkasteo, Amicus. Mr. M. Dotto, Amicus. Who is Amicus?
Midmoy Dotto.
You're there. You're there. You are the Amicus.
Yes, yes.
So why can't you do this? Let us take it up. Opposite Paul.
Opposite Paul.
Let us see. Let us make an attempt.
Yes.
Item number
Item number 66.
66.
We'll continue. We'll give you time, but let there be a beginning because they are all in the jail. No.
Yes, yes.
Yes. File number 66. Opposite Paul. Item number 66.
Here in this case, my lord, the accused person was, my lord, sentenced, convicted under life imprisonment and a fine of ₹20,000 under section 302 IPC. And in default of payment of fine, the convict Abhijit Paul shall suffer simple imprisonment for 4 months. And for the offense under section 304B2 IPC, the convict accused Paul is sentenced to suffer imprisonment for 10 years. Both under 302 as well as under section 304B.
Yes. Yes. Sir. So let us read the evidence.
Yes, yes.
Rather than you reading the evidence, we'll read out. The court will read out.
No, I was.
No, because there is a purpose. If he read out, then he can note down also. One advantage is that if we read out the evidence, my stenographer, he can also note down. Then we can pass a judgment after hearing you. Okay. Likho, Han Mr. M. Dr. Lanet Amicus for the appellant. The present appeal has been preferred against the impugned judgment and order dated 16/3/2018 passed by the Lanet Additional District and Sessions Fast Track Court Hojai, Shankardev Nagar in Sessions case number 25 within bracket N oblique 2016, by which the petitioner was convicted under section 302/304 capital B within bracket 2 IPC and sentenced to undergo sentenced to suffer rigorous life imprisonment and a fine rupees 20,000 for committing offence under section 302 IPC, and further another 10 years of rigorous imprisonment on being convicted under section 304B2 IPC. And both the sentences are to run concurrently. Full stop. Next para. The criminal process against the petitioner, against the appellant, was set into motion upon an FIR filed by the father of the deceased on 17/1/2016 before the officer in charge Hosai police station, stating that the accused appellant is the husband of the complainant's daughter Juma Paul, who had been they have been living together They have been living together in a tenanted room at Hosai Govindopalli for about 2 years, during which time his daughter was subjected to physical and mental torture by the appellant and also was demanding dowry. Unable to bear the said unable to bear the said torture meted out by her husband, his daughter took shelter in his house along with her 14-month-old son, and had been living in his house for 2 months. It has been alleged that at around 6 p.m. on 16/1/2016, the appellant came to his house promising that he would not subject her to any kind of torture and was staying in his house. It has been also alleged that at around 12:30 a.m. on 17/1/2016, the appellant strangled her daughter on the bed itself, which was witnessed by him. Full stop. It has been also alleged that the other two, he also mentioned other two accused, namely Bibha Paul and who is this Bibha Paul? Bibha Paul, the mother-in-law of the appellant, and and also a sister-in-law of the
Elder brother. Elder brother of.
no. Bibha Paul is the wife of Anil, no?
Yes, yes.
That means Bibha Paul is the mother of the accused, as well as the sister of the mother and the sister of the accused also as co-accused in the said FIR. Next para. Upon the said FIR being lodged, the police registered the case being police case number, upon the register, a GD entry was made and thereafter an FIR was registered under Hosai Police Station, case number 15/16 under section 302/34 IPC. Full stop. Thereafter, the investigation was launched, and on completion of the investigation, the prosecution submitted a charge sheet against the accused, and upon committal, the trial was conducted by the additional district and session judge Hosai Shankar Dev. At the commencement of the trial, the appellant was charged under the two. What happened to this? They did not file charge against his sister and mother-in-law. Yes, no. Huh?
Discharged by
Were they also charged?
They were discharged by the police itself.
Okay.
Charge sheet.
From the charge was framed only against the present appellant as follows, page 8, page 6, charge.
Discharged by the police itself.
Right, okay then. And charge and the other two accused named in the FIR were not charged by the police of committing any offense. Next para. In course of the trial, the prosecution examined as many as 11 witnesses and also produced the material and also adduced evidence and also produced the documentary and other evidences. The appellant accused, having denied the charge, was examined, pleaded not guilty, pleaded ignorance. While denying the charges, pleaded ignorance. Full stop. He was examined under section 313 of the CRPC in respect to the various incriminating materials and evidence adduced against him. Where he reiterated that the allegations are false and he did not commit the offense and have been falsely implicated. He, however, stated that, did not deny the fact that he was present in the house of the complainant along with his wife, and after taking dinner, he had gone to sleep. Full stop. The learned trial court, after considering the evidence adduced before it and examining and also considering the statement made by the appellant, however, held that the prosecution had been able to prove the charge against him beyond reasonable doubt, and accordingly convicted him under section 302 IPC as well as under 304B2 as mentioned above, and they sentenced him to undergo life imprisonment and 10 years RI as mentioned above. Next, before we go to the submission advance, challenging the impugned conviction and conviction order, we'll briefly refer to the evidence which have been brought on record during the trial. The first witness to be examined by the prosecution was one Miss Emily Barua, who was the circle officer of Hojai, who conducted the inquest on the dead body of the victim, Juma Paul, who testified that during the inquest, she found some marks around the neck, and after that it was sent neck. And she also testified that as per the report received from the police and witnesses, the woman was strangulated by her husband, and accordingly, the body was sent for post-mortem examination. The next witness examined was Srimati Sathi Nag, SPW2. Oh, it's a PW2 is the informant. Informant. The mother.
Yes.
पहले है ना father बना था, the mother होगा. The mother of the deceased. She narrated about their life and the marriage of her daughter with the accused about 3 years ago, and after marriage they were staying in Shillong for about a year, and thereafter were staying in a tenanted house at Govindapalli, Hojai. However, the accused had used to pressurize her daughter to bring money, to bring 2 lakhs, which was informed to her, but she could not pay the said amount due to their poverty, whereupon the appellant used to assault and torture her daughter. As a result of such torture, her daughter came back to her house along with her children. She also alleged that the accused had come to her house 10 days prior to the incident and demanded 2 lakh rupees from them. And as the same could not be paid, he created a nuisance in the house and left. She also deposed that on 16/1/2016, the accused came to their house again, but stated that she would not torture her daughter, demanding money. Accordingly, she told her son-in-law, the accused son-in-law, to stay in her house. She stated that he took meal and was staying. He took his meal in her house, where he was staying in a room along with his daughter. At around 12:30 a.m., she heard her granddaughter crying, whereupon she entered the room and saw her son-in-law strangulating her daughter by sitting upon her chest. Then she removed the hands of her son-in-law and raised a hue and cry, whereupon her husband also got up and came there. She stated other people also arrived, and when the accused tried to flee, but he could not. She found that her daughter was finding it difficult to breathe, and immediately took her daughter to Hojai Civil Hospital in an auto. Then later on to HAM. What is this? HAM.
HM, my lord, the hospital name, my lord.
To another hospital, within bracket HAMM, where she was declared dead. She deposed that the accused was handed over to the police that very night, and later on she lodged the Ejhar. since she was a important eyewitness, she was subjected to cross-examination, of which we'll make reference at appropriate stage. Next paragraph. The next witness examined was Sri Dhirendra Nath, the father of the deceased, who disposed more or less in the same line as his wife within bracket PW3. As regards the incident also, he stated that on the day of incident, his son-in-law was sleeping with his daughter, and at night, as their granddaughter was crying, his wife entered the room and she saw her son-in-law, appellant, squeezing the neck of his daughter. And as his wife sounded an alarm, she also went there. And the accused was apprehended there itself. The next witness examined was
Ashish De.
There was one Ashish De, who is the elder brother of the deceased. No. Who is the Shasna is my sister. Who is the uncle of the deceased? That is the elder brother of the informant, the mother of the deceased. He stated that on the day of incident, he was in his house. He was informed over phone that his niece Juma Paul was seriously unwell, and accordingly, accompanied by his younger brother, Bijit De, went to the house of his niece. And on finding the condition of his niece in a critical, on finding the condition of his niece critical, and seeing his sister wailing and weeping, he immediately took Juma to Civil Hospital, Hojai. And thereafter to another hospital, Hojai, where the doctor declared his niece to be dead, declared his niece dead. Later on, he was informed by his sister, PW3, that accused used to torture his niece, demanding 2 lakhs. And that his sister PW2 also told him that accused had strangulated Juma by sitting upon her chest. He also stated a black mark was present on the neck of his niece, deceased niece. The next witness examined was PW5, Sanjit Chandra De. Another younger brother of the complainant and the uncle of the deceased, Juma Paul. He also testified in the same line as PW4, who had gone to the house of his niece along with him. The next witness examined was Srimati Taposhi Das as PW6, who is a neighbor. She stated that upon at around in the night of 6 January 2016 at around 1 a.m. Upon hearing a hue and cry in the house of the informant, she went there and found Juma Nag dead. And she was not breathing. And she found Abhijit Paul, the appellant, standing nearby. She was then informed by the informant, mother of the coma, the mother of the deceased, that the accused had strangled her daughter Juma. She also stated about the demand of dowry or rupees 2 lakhs as told to her. She also heard later on that there was a quarrel between the wife and husband and that the accused had demanded a dowry rupees 2 lakhs. She also stated that she noticed a red mark on the neck of Juma. Next para. The next witness examined was Sri Subhash Majumdar, is PW7. Who is also a neighbor, who stated on hearing a hue and cry, he went there and saw the Juma hue and cry on the day of the incident. He went to the place of occurrence and saw the deceased lying on a bed. He also stated he heard that the accused had assaulted the deceased, demanding rupees 2 lakhs. Next para. The next witness examined was Srimati Monica Mondol as PW8, who also a neighbor who was in the neighborhood. She also stated that at around 1 a.m. in the night of the incident, upon hearing hue and cry in the house of the deceased, she went there and found the mother of the deceased wailing, and on being asked, the mother of the deceased stated that Juma has been strangled by her husband Abhijit, and she saw Juma lying on the bed and was not taking breath. She also noticed a mark on the neck of Juma. She also stated Abhijit had a quarrel with Juma 10 days prior to the incident. When asked why she was crying, Juma replied that, what is this? Seeing Juma weeping, I understand. I think wrongly recorded, no? Page 25, last sentence, seeing Juma
Yes.
weeping, huh?
Seeing Juma weeping.
That must be. She also came, she also seeing the mother of the deceased weeping. She asked her as to what had happened, whereupon she stated that the appellant had assaulted. Huh? What is this? Something wrong? Huh?
The original is an African.
Original. Juma is the daughter, no? Who died.
Yes,
How can she asked Juma? Original. Anyway, notice a mark in the neck. In any way, huh? I think must be mother. When she applied, obviously assaulted her, demanding to.
As much as bad, handwriting is not very good.
Please check it up in the meantime. Yes. The next witness examined was Rothindra De as PW9, who is also a neighbor, who mentions that on the day of incident in the night at around 12:31 a.m., upon hearing a hue and cry from the house of the informant, he went there and saw Juma lying on the bed and saw both her parents weeping and sitting near her. On asking the mother of Jumma, she replied that the accused had strangulated her daughter. Thereafter, he informed the maternal uncle of Jumma over phone, and they came and took Jumma to the hospital where she expired. She also stated that he also stated when the accused or Vijaypal tried to flee from the scene, he was restrained and apprehended. She also stated that 10 days prior to the incident, the accused had assaulted Jumma, demanding 2 lakhs from her, rupees 2 lakhs from her, and that he witnessed the said incident. Next para.
10 days back, she saw both were fighting and Juma was crying.
Oh, that PW?
PW8.
Oh, PW8, na? PW8. PW8 also stated.
জুমাক বিছনাত পৰি থকা দেখিছিলো, উশাহ নিশাহ পোৱা নাছিল। জুমাৰ গলত দাগ দেখিছিলো। 10 দিনমান আগতে জুমা লগত অভিযুক্তৰ কাজিয়া কৰিছিল। জুমাই কান্দি থকা দেখি সুধিছিলো।
Okay. She also stated that about 10 days ago, she saw Jumma and her husband quarreling, and upon asking her for the reason, she stated that her husband was beating her and demanding rupees 2 lakhs. Do women produce money or what? Huh? Women produce money or what?
This
Huh?
is what they think.
Huh? Huh? I don't know. Why they always ask money from women. Whereas they have a magic to produce women. Demand and you give. They are authorized by RBI, women, to produce money, I think. Especially Indian women.
They don't think.
That's why Indian men always ask money from Indian women.
And
Huh?
surprisingly, it's still continuing.
It's still continuing. And some of them also give also, no?
Give also parents under the
Yes.
pressure, they will torture their daughters, so they give. And in today's world, there should not be a.
Of course, he will deny, of course.
Everyone denies.
And he will see that.
There are so many evidences.
Anyway.
Space for denial.
The next witness examined was PW10, the doctor who conducted a post-mortem report, a post-mortem examination of the dead body. And he deposed that on examination, he found the following. He found that the ecchymosis. What is ecchymosis?
It's a mark.
Mark. Ecchymosis is a mark, huh?
It's a bruise kind
Bruise,
with blood underneath.
He deposed that he found ecchymosis was seen approximately 5 centimeter length into half centimeter breadth on the right side of neck, reddish in color, and her face was pale and lips cyanosed on back of neck. And according to him or her, this doctor, according to him, the death was caused due to throttling or mechanical obstruction of air passages within bracket asphyxia due to throttling. Next para. PW11 is the IO who conducted an investigation of the case. And he testified the manner how he conducted the investigation on visiting the place of occurrence and examining the witnesses. Seizure of mobile phone accused, is it relevant? Huh? Has it been, he said, I seized one mobile phone from, has it been used? No,
Not really.
not relevant.
Cross-examination only, they ask.
They just seize like that. I don't think they don't do anything. Huh? Police, they don't do anything. They just seize the mobile. Huh? They don't find out. But what they will find out, because the incident is not based on mobile.
He in fact confessed, he said during 161 accused statement.
Oh, that is, there is no point. 161, they will say anything.
They only doubted that he has not taken some impression. That is the problem.
Okay, so that's the evidence against him?
Yes, my lord.
Yes.
It's-
Yes, then we'll just record your statement also, 313. After having examined after having recorded the evidence of the prosecution witnesses, the appellant was examined under, and his statement recorded under section 313 CRPC.
Is written 364.
Huh? Oh,
Written,
that's
my
a
lord,
Purana,
364.
Purana. The 360 Purana. There's some, in some codes, the Purana forms are there. That is why. 364 CRPC is the old CRPC. Yes.
89.
Yes. Regarding the question put by the court about the allegation against him that he had demanded 2 lakhs from his wife and about the torture.
In page 34 and 35, I think it will become 36.
Oh.
My lord, I did not commit any such offense as I was falsely implicated with
And
the
that's
case.
what, that's what we wanted to record. And about the incident as stated by the PW2, the mother of the deceased, the appellant gave his reply that he did not commit any such offense and that he was falsely implicated. He stated that on the day of occurrence, he had gone to the house of the informant where he showed his wife massaging her daughter's body as she was feeling pain. Thereafter, after taking dinner, went to sleep. And he stated there is no reason why he should kill his wife,
He has a minor son.
as he has a minor son. Then question number 3, no, number 3 false.
There is no
He
specific
denied
reason for mine.
having demanded any money from his wife or her parents. Any other evidence?
I had never demanded any money from
Yes,
them.
PW6 page 37. He said that he admits some offense. Page 38.
Mhm.
At the time of occurrence, she came to the place of occurrence and saw the eyes of the victim and no other person came.
As regards the allegation, as regards the evidence of PW6 that she had come to the place of occurrence and also saw the accused sitting, he answered that he stated that he had not committed any offense, and at a time of occurrence, the PW6 had come to the place of occurrence and saw the eyes of the victim and no other person came there. Thus, as per his statement under record under section 313, he had admitted the presence of PW6 at the soon after the incident had occurred. He, however, had denied that other witnesses, namely 7, 8, 9, did not come to the place of occurrence as stated by them.
My lord, he has clearly, my lord, stated, my lord.
Yes,
My lord, the appellant, my lord, he has
Mhm.
clearly stated, my lord, he has never demanded any money.
that
from
we have recorded, yes, that we have recorded. However, he also declined to adduce any evidence in his defense. Yes, sir. Next one. However, next one. The learned trial court, after appreciation evidence on record as mentioned above, held that the charge against the appellant has been proved beyond reasonable doubt, and accordingly convicted him as mentionable. Yes, what is your submission? Please tell us.
My lord, it seems,
have-
my lord, only,
Yes.
my lord, PW1 is the eyewitness, my lord.
Yes,
Others all are, my lord, hearsay.
PW1,
PW,
yes.
PW2.
PW2, yes, is the eyewitness.
My lord, let's,
Let us see then PW2, how did you cross-examine?
yes, PW2. my
Two,
lord.
yes, cross-examination, huh?
My lord, before that, my lord, I just want to point out, my lord.
Yes,
My lord, in this sheep, my lord, she deposed, my lord, around 12:30 AM. I heard the child of my daughter crying, whereupon I entered that room and saw my son-in-law strangulating my daughter by sitting upon her chest. Then I removed the hands of my son-in-law and sounded an alarm. My husband got up and came there. Other people also arrived there. My lord, regarding, my lord, removal of hands from
Hmm.
the of the son-in-law, my lord, from the neck of the, my lord, her daughter, my lord.
Hmm.
That part, my lord, that was not stated before, my lord, police, my lord. That was developed, my lord, during, my lord, while adducing her evidence, my lord.
But does it really matter? Suppose you disbelieve that, but she saw at least that he is strangulating. That is good enough.
My lord, he was suffer, my lord, as per, my lord, my understanding, my lord. See, the deceased was suffering some pain, my lord. That's why, my lord, the appellant, he.
But then see, correct, but then the medical report says that she died because of throttling.
My lord, medical report also, my lord, says, my
So
lord.
let us see the medical report, cross,
Cross-examination.
not cross-examination, the post-mortem report. Let us read, what does it say? What is the medical evidence, post-mortem report, identified, not decomposed, page 61, 2, wounds and position character, number 2, ecchymosis seen, approximately right side red pale, lips, sinuous and back. So this is that. Then what is the opinion given by the doctor?
Whose position and size nature, that is absent.
Then
Mark
see,
of ligation on neck, that is also absent.
but then come to page 63, muscle bone injury on neck. Injury was found on neck.
Injury was found on neck.
Neck, yes. Then page 64, opinion. In my opinion, death is caused due to throttling or mechanical obstruction of air passages, asphyxia due to throttling.
My lord, or mechanical obstruction of
Yes,
air passage.
correct.
my
No,
lord.
no problem. And then mechanical. Now, what is the cross-examination?
Yes,
If you see that, let us see the cross-examination of the doctor by you. Let us see. Page 29, page 30. Cross-examination.
I
I
examined.
examined the dead body. I did not mention specifically how and what substance mechanical was the cause. I did not mention the time of dead person. Death can be caused immediately after obstruction from reason. I did not. So.
I did not properly examine the dead body, man.
No, it is not that.
It is not a fact. I did not mention specifically.
How and why the
by what
mechanical-
substance the
obstruction was-
mechanical obstruction was caused.
It may not be recorded because how do you know? The hand, it may be, whatever, he has already stated. He stated that especially as from opinion that was due to throttling. Throttling means what? Who will throttle?
Obstruction or throttling. my lord.
Or mechanical obstruction of air. Now it is for you to explain, I mean, give doubt to that. He said this can be throttling or mechanical obstruction. Mechanical obstruction, it may be by pillow, it may be by hand also mechanical.
Yes,
No?
mechanically.
Mechanical means what? Mechanical means use of some force from outside, external. That's mechanical. Mechanics is external,
My lord,
not
actually,
automatic.
in this case, my lord,
Ah.
I have also prepared, my lord, but my lord, today, my lord, I am not.
No problem,
prepared,
we'll
my lord.
hear you. Tomorrow we'll
Actually,
hear you.
Yes, my
Tomorrow
lord,
we'll prepare to
I have make some notes also, my lord.
No
so-
problem, no, we'll hear you. Only that we know what is the evidence now. You
Yes,
argue
yes,
your
yes.
case, now, no
Yes,
problem.
yes.
No issue. We'll hear you tomorrow.
Tomorrow, my lord.
Okay. Hearing will continue tomorrow. In the meantime, you type it out. At least the records will there. Fact. We'll see that, no problem. We don't want to rush anything, especially
302.
appeal, yes, 302. We have to be careful. We'll hear
Yes,
you.
my lord, I have to, my lord, 304B, my lord. There
Ah.
also, my lord, question of presumption will also come, my lord. Whether 304B attracts or not,
Correct.
that is also in one aspect.
Correct? Yes, yes. But 30B is for dowry.
Dowry.
Forget dowry, because dowry, they may say, demand. But then though one PW6 or something like that, she also heard, no, that 10 days before I saw them quarreling.
My lord, that is there, but my lord, whether that statement
Correct,
was.
that statement is sufficient to, dowry, yes. Of course, we'll see that.
No FIR as such, my lord,
Uh-huh.
regarding dowry, my lord,
Ah,
because 10 days back it was,
Correct,
but to
correct.
that effect, there was no FIR, no, nothing, my lord.
In village, people don't go to police station. Nobody wants to go to police station. Police station is the last resort.
But my lord, when it was, my lord, occurring frequently, my lord, naturally, my lord, they would.
Because after all, they were staying with them, after all, they want to see, that's what they allow him to stay also. He said, I am not going to harm. I am not going to demand. Okay, then you come and stay. That's the evidence. We are not saying
Yes,
anything.
yes.
Because the parents, what they will do, they want to see their daughter to be happily married. They don't want any unhappy marriage. They want happy marriage, not unhappy marriage. So if they feel that the husband is now coming to senses, he is not demanding dowry, okay, you go and come and stay with us. We are not saying anything.
Yes,
That
yes.
the parents, they never want to, if the parents are willing to sacrifice, so long as the daughter is happy. So they will not, why should they send, if they file a FIR, then he may be more angry, then he will start beating more also.
In this
Of course,
case,
the beating, of course, I don't know, the other evidence is not there, of course. Assaulting earlier,
regarding
torture,
assaulting and other.
torture and all this earlier torture, that evidence is not there.
There is no evidence, my lord. No FIR.
304, that evidence is sketchy.
Neighbor,
PW6 and mother.
Ah.
Mother is there, of course, mother.
Mother narrated to the witnesses, then the witnesses came.
No,
to-
except for PW6 perhaps.
Ah.
6 says,
Six.
10 days before,
Ah.
I saw them quarreling.
yes.
And when I asked Jumma, why you are quarreling, why you are crying, then she said, no, this fellow has been, my husband has been beating me and asking 2 lakhs.
Hmm. That is there.
And she's
So
a
some
lady.
assault, some torture, physical as well, mental, those were there. 304B, of course, is sentenced for 10 years.
10 years.
302 life is
So
given.
life is there. So 30, the principal main offense is still there.
Yes, yes, that I understand, my lord. but,
Yes, yes. No problem, you can come tomorrow, no problem. Tomorrow is key. Tomorrow is Thursday again,
Date reference.
dead reference. I said tomorrow I am told there is a dead reference,
Or that
but-
Pathat,
Padhar matter. So you be there, if you see, then we'll see. If it can be, then we'll,
otherwise day after,
or day after tomorrow. Day after tomorrow, mane ki?
Friday.
Friday. On Friday also we can hear you. No, if you are ready,
Yes, my lord, on
then you
Friday-
come on Friday.
Friday.
Don't do day after, because otherwise you'll be just waiting. You don't know when this dead reference will conclude. I think it will be Friday, huh?
Yeah.
The hearing will continue on Friday. Single bench, nagi. Single bench will take it. Okay, we'll. I will. Single bench lawyers are there, counsel. Single bench are there. Okay, I will come then. Still, we have 20 minutes. We'll come. Sixteen.
Yes, lord.
Okay, on the prayer of, what is your name?
G Kaushik.
G. Kaushik. Or having obtained consent from the site, place for adjournment. Yes, next.
Lordship may be listed after vacation.
After vacation. Is paid, the matter will list after vacation. Yes, Nick. Which vacation? Winter vacation.
Yes,
Bihu
Lordship, winter vacation.
Winter vacation, because there are so many vacations. Winter vacation, then Bihu vacation.
May I
Then-
please your lordship? Lordship, I'm praying for listing of an IA for correction of orders, lordship.
This matter, arbitration matter.
Lordship. Lordship, tomorrow.
No, tomorrow. Tomorrow, then I have to sit only for you. Then the court will say, why discrimination only for one lawyer? Monday?
Lordship.
Monday.
May I please your lordship? So I'd like to mention item number 10.
What do you want? Tell us, tell
2
us.
weeks time may be granted for filing rejoinder reply to the affidavit.
You have
of
other side, yes?
have
Okay,
this.
Mr.
AA Ahmed.
And so, having obtained, I have place for how long?
For 2 weeks time.
2 weeks time to file?
Rejoinder reply.
Reason to the affidavit filed by the respondent.
Respondent.
Are also Miss
Are not
Anna for the respondent. Yes, next.
Highly obliged.
obliged to your lordship.
May it please your lordship, with the consent of the other side, I beg to mention item number 11 of the daily list, your lordship.
11.
In this matter, senior counsel Mr. D Das appears, he is out of station, your lordships. This matter may kindly be taken up after 1 week.
Okay, on the prayer of Miss,
S. Sharma, your lordships.
matter be listed after a week.
Deeply
Next,
obliged.
712.
yes.
So I beg to mention item 12. That respondent.
What is item 12?
Is that
Item number 12, what is the name of the case?
Sahidur Rahman, Mission Director versus Sahidur Rahman.
Saidur Rahman, presentation director. You are for whom?
Respondent number 1, sir.
You are for respondent number
On behalf of respondent number 1.
1. What do you want?
This may be lordship 1 week time.
1 week time. Yes,
Lordship, the petition council has informed due to some sudden bereavement, Lordship, may be taken up next week.
okay, on joint prayer list after a week. Yes, next.
I'd like to mention item number 8, lordship.
Yes,
Yeah, I am the petitioner, lordship. I have
Yes.
this is a father and son dispute, lordship, arbitration matter.
father and son,
Father, son, brothers. I
father,
need
son,
some-
brother,
I
family
need some-
dispute.
Dispute, I need some instruction from my petitioner, so.
You are for whom? Son.
Father and brother.
I'm for the respondents, my lord.
Respondent means?
Father and brother.
Where he has filed the arbitration.
No, I am asking whether you are the father, son,
Father, my lord. Father
Father.
and the
I'm the son, lordship.
you are the son.
I need some instruction from him. I call him.
Why don't you listen to your father?
Lordship.
Why don't you listen to your father? The matter, the problem will be solved. You don't want to listen to your father.
Lordship.
That's the problem.
Lordship. Lordship.
This matter actually, my lord, is very small issue.
Lordship, then also, lordship, I need some instruction from my petition.
This also indicates you have not taught your son properly. Therefore, he is not listening to you. The small matter also, he is not listening. Huh?
Lordship, let it come after 2 weeks, lordship. I need some time, lordship. By the petitioner, lordship, I'm paying, he's objecting the arbitration part.
But we are objecting. to
And
the
here,
appointment
section
of
9
arbitration.
petition also, it will, I will be in the.
I leave it to my lord, if it is inconvenient.
You
to
are
my-
the son.
Yes, lord.
You want arbitration
I want arbitration.
and you don't want.
No, because there is no.
There is some
question, my lord.
legal
My
points
lord,
they are
yeah.
raising.
There is no arbitration clause at all.
As per their interpretation, lordship.
Okay, then, okay, we'll hear then. So when?
After 2
Any
weeks,
day
lordship.
convenient to my lord, my lord.
After 2 weeks, lordship.
Give a date.
After the.
After 2 weeks, they give a date.
Lordship,
No, no,
22 December, lordship.
22 December.
14, 15 December, lordship. In the
14 December.
14 December is okay.
Okay.
14 will do.
Okay, on joint prayer list on 14 December. Yes.
Obliged.
Lordship, I think it will be problematic for him on the if he said joint prayer, lordship.
Joint and my lord, let him take.
Father is always willing to forgive. You are the one, you are not listening to your father. Father has tolerated a son all nuisance they create in their childhood. So they are willing to tolerate all these nuisance even in adulthood also.
Lordship,
I'm
lordship.
deeply obliged. Deeply obliged.
Next.
Daily list for admission, item number 1.
Nayak, what is this Nayak? What is to be done?
This is a petition, this is a petition we are claiming,
Arbitration.
appointment of.
You are not agreeable.
My lord, the judgment which they have relied, my lord, is pending before the larger bench, my lord.
Oh, that one, central.
Central Organization for Railway
Okay, then,
Electrification.
okay. It has been submitted that it will be appropriate to await the decision of the larger bench in respect of which has arisen on account of the difference of opinion of the Honorable Supreme, the cognate benches of the Honorable Supreme Court in central organization, so and the TRF. Huh? No, not TRF. What is that?
ECI, SPI.
No. Central and others.
Another is Union of India versus Tatia Construction.
Tatia, yes.
2021 SSC online,
Yes,
SC
yes.
271.
Yes. According list the matter after, There are list the matter after decision of the larger bench of the Honorable Supreme Court. Next,
1, 2, 3, 4, 5.
1, 2, 3, 4, 5, same.
Same.
1, 2, 3, 4, 5, and 6.
Item number
Padamraj.
6.
Padamraj, yes, what is to be done? Padamraj.
Here I am for the petitioner.
Who is for the respondent?
Railway is for the respondent, Lordship.
Railway, is there an issue like that also? Similar issue?
No, here issue is different.
Okay,
Here
where is the
they-
railways? Where is the railways? Railways are running late, not to be
They-
seen.
They raised an issue, Lordship.
Mister, but where is the railways? They have not reached the station. Train is running late today.
I need to find.
Yes, you are for the railways.
No, my lord, myself, I am for the IRCTC, my lord. In
For
this,
the?
IRCTC, Indian Railway Catering and Tourism Corporation.
Catering. And
That
who is for the
point number
railways?
5. That Uma, Madam Uma.
Where is
she
Madam Uma?
She is not present today. I didn't see her.
Maybe
It can be
she-
posted another day, your lord.
Lordship,
because
let me find,
IRCTC
let me find
for
a rejoinder in the meantime, Lordship.
Okay.
Lordship, may I make one prayer?
Yes,
The petitioner is presently at Kerala, Lordship. He will come on 15th of December.
yes.
Can it be listed anytime after 15th of December?
Anytime you tell us, they give a date, did you give a date?
Lordship, 19th of December, Lordship.
Okay, list the matter on 19th of December. In the meantime, the petitioner will file a rejoinder affidavit. Rejoinder affidavit?
Lordship.
Okay.
Develop.
Are also Mr. Lanet appearing for
Respondent number 5. your lord.
respondent number 5. Annex, and annex for respondent. Yes, next.
Oh, right.
Item number 7.
Durga Krishna. But it is also that
Yes, yes, my.
way,
Yes.
larger bench.
Same. like-
Same larger bench. Mani Shankar Das.
Already mentioned. Item number 9.
9, okay. Mani Shankar Das, item number 9.
Yes,
Yes,
Lord.
yes, what is this?
Can it be after 10th of December?
You want arbitration, you are objecting? Huh?
Yes.
On what ground you are objecting?
No, she's not objecting to the adjournment today.
No, I am asking for the adjournment of the arbitration. Why you are objecting to arbitration? Tell us. You are not prepared. Madam, the file was with you all the time. 10:30, the file was, you have brought it from the chamber. Huh?
Yes.
How many pages? See, madam, if you don't read now, then how will you learn? See, life is all for learning. We also are junior, not like you. One day we were also like you. The senior will give the file, you don't know what to do. What is this file about? But in the meantime, you go through it also, learn. That's how we learn. Because the senior is not going to teach you like that Gurukul system. No, oh, come. The senior is sitting there. He won't have time to gather all the juniors and teach you lessons, no? Porile, have you read? Yes. You haven't do, then do. Okay, do that. So unless you read as a junior, the junior main responsibility is to read. Then you will understand. If you don't read, the problem will arise. Okay. So what do you want now? Adjournment.
Adjournment.
Do you have any objection to adjournment? Okay. Then it will be listed when?
After 10th of,
10th
after 10th of December.
Give a date, don't say after, because after 10 means, it can go for years together. It may be listed after 3 years also.
13th?
Huh?
13, 12,
In holiday. 13, 11.
13, 12,
13, 12.
December.
December.
14. What about 14?
14.
14 is after 13?
Yes.
Okay. On joint trial list on 14th. Next, item number.
For orders, item 13.
Samudit Boruba. What is this? Lanet Senior Council?
The parties were not appearing, so we took steps as per order dated timeline, my lord.
Okay,
So we have enclosed the process which we have taken,
okay.
and also WhatsApp message, there's a document fixed for hearing and my lord. Next
Okay,
party.
okay, Mr. Lanet Senior Council assisted by Ms.
Enough.
Some is that the petitioners have taken step, petitioner or petitioners? Petitioner. huh?
Petitioners, my lord.
Petitioner have taken step for the service of notice upon the respondent by, as directed by this court.
Publishing newspaper. my lord.
By publishing newspaper. List the matter again on so and so to enable the respondent to appear. This list again, giving another opportunity to respondent to appear. Thereafter, the matter will be considered
Right.
as per law. List after so and so, huh? Then when?
19th December, my lord,
19 December. Okay, 19 December is
Monday, my lord.
Monday. Okay, 19 December.
Obliged.
Yes. Hearing. Review.
hearing, item 14 and-
What is this? Nasiruddin.
May I please the-
What is this
But in
Nasiruddin?
this case, my lord, record was called for.
What is the record? Have you called? Have you got the record? Yeah, Mr. Khotunia, record?
No, my lord.
No, when you want? When?
Next, after 2 weeks, my
Mr. Khotunia submitted, he may be given some more time to produce the record. List accordingly on,
Noted may be given because
not given, oh,
Already lot of they have given
Even
enough time.
enough time, Mr. Khotanio even given enough time. So what did you tell us?
But I thought it may be a.
Short date, okay. Yes, Mr. Khotanio, take a short date.
15 or 16th, my lord,
Yes,
14th.
list the matter again on 14. Her also Miss Devi, also Miss
Earlier intent would have maybe.
Ali in the model will continue. Yes, next.
List over.
This over.